Lord, I pray for listing of an interlocutory application in a criminal appeal matter for withdrawal. Lord.
As with your lordship, item number 16 on behalf of Venkiras due to ill health of my senior.
Item
Item number 16.
16.
Due to ill health of my senior, your lordship will kindly pass over the matter and fix another day.
Yes, Your Lordship. That's it. I need to mention item number 15 on behalf of Mr. H. Gupta.
Just one minute. Item 16, we are not passed order. Item 16.
Please.
Okay. On the item 16,
Sorry.
on the prayer made by Learned Counsel for the applicant, matter stands adjourned today. List when?
Your lordship, any fixed, any short.
List of. Yes, item
I mention item number 15 on behalf of Mr. H. Gupta.
15.
He's suffering from fever, Lordship. So, matter may kindly be down for a week.
Okay, these hearing matters would otherwise be adjourned.
Right.
Because we are taking up another series of matters. This will be otherwise adjourned.
He's suffering from fever, Lordship. Okay.
Daily list, item 1 for admission.
1 to 3, jail appeal. Mike is correct from the list. Ms. S.S. Bharat for the appeal. Just say if it is POXO, then it will be through APP, otherwise the jurisdictional magistrate. Okay. One, 2, and 3, all we are issuing notice.
Is it the one of them?
1, 2, 3. Side. Yes, item 4.
Property.
Yeah, Mr. Lodge. My lord, this is an appeal, the section 21(4) of the National Emergency Act, my lord.
Yes, come for the first time.
Yes, ma'am.
Issue notice. How much time? 2 weeks? 3 weeks? Okay.
For NI.
And Mr. K. Sinha, counsel for the appellant, and Ms. L. Devi, learned counsel appearing on behalf of standing counsel for NIA. Issue notice on this appeal under section 21(4) of the NIA Act against auditors also. Appeal is admitted for hearing. Call for the scanned copy of.
This is NI case number 12, ma'am. This is NI case number 2/12.
No, they will not at all. Scan copy of the. I don't think any scan copy is required from the trial court.
My lord, it's required during this evidence part.
Okay, scan copy of the evidence of the prosecution witnesses from the court of learned, from the learned trial court. Next, the registry is permitted to send the requisition through email with liberty to the learned special judge Nia Assam to transmit the scanned copies through email or being placed before the court. We have notices 3 weeks, list after 3 weeks.
Item 5.
I have already taken step for twice.
We don't find that you have taken steps. When you have the acknowledgement.
Not available from Mohri Lordship. I have myself taken step Lordship.
No, we are not doubting that you have taken steps.
Twice.
But if it is not reflected, you'll have to take fresh steps again. It is not here. Otherwise, if you have the acknowledgement, we could have directed.
So,
Pardon me?
Lordship, 2 o'clock. Lordship.
Tomorrow?
Yes, Lordship, then tomorrow.
I'm not hearing you. Please repeat again.
Tomorrow, Lordship wants to produce the acknowledgement
No, but it will not be listed tomorrow.
next.
It will go to next week.
Lordship, there is an IA is filed for bail, Lordship.
No, but unless this notice is issued, we can't do anything. Ms. A. Begum, learned counsel for the applicant, submits that she will produce the acknowledgement of having taken steps for service of notice on respond number 2. List on Monday. Ss Bharal and APP is present. Monday will be 4th March.
Item 6.
Yes, Mr. Das.
I think that's an endorsement. It has been returned answer.
Give the supplementary file. Does it give the supplementary file? Shantanu? First file what is it? Return answer. Mr. Das, this process, it will be, it's a POXO matter, so you'll have to serve it through the jurisdictional police station. Which is the police station? Answer. Bongaigaon.
Bongaigaon Police.
It is ending.
Mr. Das, you'll have to wait for some time.
Yes.
It appears that the note has been put up very casually. So we are calling the concern. Huh? There's no, it appears it is casually written, so we're asking the concerned officer to be here. But we'll pass an order to serve it through the judicial Bongaigaon police station through your establishment. Just wait for some time. You may not be here. We shall let her be here.
Item 7,
I need to express statement. So kindly allow me 2 weeks time.
You take it through the APP, this POXO matter. You take it by Monday, then we only have to give the typed notices. Uh, In terms of order dated 13/10/2023, Ms. M. Das, Legal Counsel shall take steps in an appropriate manner for service of notice on respond number 2 through the officer in charge of Haflong Police Station to be routed through the Office of the Public Prosecutor, Assam at Guwahati High Court. Stop notice is made returnable on, give after 6 weeks.
19th April.
Steps within 4 days. The officer in charge of the of Haflong Police Station shall ensure that the service report is returned prior to the next date of listing. I will be considered on service of notice on respond number 2. The record is present, K.K. Das.
Item 8.
The parties have filed their opposition.
You have filed on 26th, Lordship.
So we'll list it on Monday.
I have given the
We'll list it on Monday.
Lordship.
Okay. Mr. P.K. Muni, counsel for the appellant, Ms. S.H. Boraland, APP, as well as Mr. N.J. Goswami, counsel for respondent who are present. Objection filed by the respondent 2. Which is not on record.
Both are not on.
Achha, the objection filed by the London APP as well as the counsel for respondent 2 is not on record. Let the registry tag the same on record. List on 4,
Can it be on Tuesday, Lordship? 5th,
then Wednesday,
Wednesday?
6th.
Or Wednesday?
Item 9.
As per the office note, your Lordship. As per the office note, service is not complete, your Lordship. Your Lordship has directed us to take instruction, Lordship. We have taken the instruction. Notice has been duly served upon respondent number 2.
So
Yes,
you have that.
and that is perhaps on record, Lordship, I have given to it. With a copy.
Take it out.
Yes, it is there, Lordship.
Definitely, sir, beside law. That's what is it. After 5 minutes,
Lordship.
next.
Item 10.
Yes, dear Lordship, my lord. Regarding the service of a respondent number 2, we went there, but she refused to accept the notice. That's why we have. filed
But from you she will never receive it. You were never asked to serve it by Dasti. In a
Yes.
criminal,
That we have done, we have filed also affidavit.
no. In criminal case, have you allowed you to serve by Dasti? Criminal cases, we don't normally pass such orders. Criminal cases, we can't accept the service.
There is no such concept.
No, this,
in criminal.
I don't know, we may have inadvertently passed orders.
That was, or
It is there. No, but in this,
yes, normally, but
we can't take it.
after whether notice.
So this is a civil mode of service. It's not a mode of service prescribed under the.
This writer only order was there and we served. We went to serve, but she refused. We have filed justice service.
No, we can't take.
Now, Lordship may kindly appoint the amicus curiae.
No. Notice has to be served to the, then we can appoint. But this mode is not prescribed under the Guwahati High Court rules.
We have
We can't
also
accept.
served through PPOs.
Where is that? In POXO, it will be a violation of Supreme Court guidelines. There's a strict direction of the Supreme Court by a judicial officer, judicial order of 3-judge bench, that in POXO matters, the victim and the accused, they can't meet.
So we have taken in both ways.
No, it's okay. It's our mistake, but. Yes, you have got it. Steps. Have you got the steps?
In item number 10, Lordship.
Yes.
That is perhaps awaited, Lordship.
Heard Mr. M.U. Mahmood, learned counsel for the appellant. Also heard Ms. S.H. Bora, learned additional public prosecutor. It appears from record that by order dated 8/1/2024, the appellant was also allowed to take steps for service of notice on respondent number 2 by registered post with AD along with and also through Dusty mode. The applicant has filed affidavit of service, affidavit on regarding service of notice through Dusty mode, wherein it has been mentioned that when the appellant's lawyer, when the respondent number 2 was approached by the approached, she refused to receive the service, receive the notice through Dusty mode. As this case involves offense under section 376 within bracket 3 of the Indian Penal Code, as well as section 4 of the POXO Act, we are inclined to direct we hereby and there is a a division bench of this court has directed, has laid down the guidelines
Deepak Nayak.
for in Deepak,
Deepak
in division bench of this court in Deepak Naik, in the case of Deepak Naik versus State of Assam, has laid down the guidelines for service of notice on the victim slash guardian of the victim slash support person of the victim through jurisdictional police, through the officer in charge of jurisdictional police station. Hence, accordingly, we hereby direct the applicant to take fresh steps as per the mode prescribed in the case of Deepak Naik versus State of Assam. The petitioner shall furnish the fresh written up notices along with the copy of memo of appeal and application under section 389 CRPC to the registry, which in turn shall hand it over to the learned additional public prosecutor, who shall ensure the service of the said notice on respondent number 2 through the officer in charge of jurisdictional police station within, that is, officer in charge of
Paneri Police
Paneri
Station
Police
in the
Station,
district of Udalguri.
returnable on give a date.
After how many weeks?
Lordship, 3 weeks.
27/3,
Returnable
27th of
on
March.
27/3. 24. List this case accordingly.
Obliged, Lordship.
On,
27.
27.
obliged. Restrictive,
You take this back. ঘুরাই দিব পেপারস একটু ঘুরাই দিব
I have been দুইটাই provide করেছি।
এটা অন্য বেশি
Time being item 9.
করে দিও ঘটনা
Heard Miss
F Hussein, F Hussein.
Yeah.
F,
F. Hussain. This is item number 9.
9, Lordship, item number 9. MS F Hussein.
Heard Miss F. Hussain, learned counsel for the appellant. Also heard Miss S. H. Bora, learned additional public prosecutor, who has submitted that the notice issued to respondent number 2 has been served through the officer in charge of jurisdictional police station. And in support of her submission, she has placed the service report, copy of service report issued by the officer in charge of Panigaon Police Station on record. The notices is a notice on respondent number 2 is accepted to be duly served. The paper book is ready and this case is ready for hearing. List this case for hearing in its due course. In IA you will be filing objection
Lordship.
in interlocutory application also. Heard Ms. F. Hussain, learned counsel for the applicant. Also heard Ms. S. H. Bora, learned additional public prosecutor. Notices on respondent number 2 are duly served. The learned additional public prosecutor has sought for some time to file objection against the application for suspension of sentence filed by the applicant. The prayer is allowed. How much time?
Lordship, 2 weeks time maybe.
Let this case be listed after 2 weeks. The case record of criminal appeal number 347/23 be tagged with this interlocutory application. In the meanwhile, the additional public prosecutor shall file the objection before the next date fixed, list accordingly.
Obliged.
Your lordship, a date may be fixed.
27th of March.
27th.
Obliged.
Obliging.
Item 11.
Yeah, please.
Please, your lordship, by order dated 19/1/2024, this honorable court directed to take steps to respondent number 2. You have taken steps, lordship.
You will have to take steps.
You have to take steps.
No, you have taken only once, but through police station also you'll have to take. You take steps.
Heard Ms. B. Gogoi, learned counsel for the appellant. Also heard Ms. N. Das, learned additional public prosecutor. On perusal of the office note dated 26/2/24, it appears that though the appellant has taken steps for issuance of notice on respondent number 2 by registered post with AD. However, no additional processes were paid over to registry for taking step for issuance of the notice on the respondent number 2 through jurisdictional police station, through the officer in charge of jurisdictional police station. The applicant shall take fresh steps for service of notice on respondent number 2 as per the mode prescribed by a division bench of this court in the case of Deepak Naik versus State of Assam within 3 days from the date of this order, returnable on the date after 2 weeks. Returnable on 29th March.
29th March holidays, 27 March.
27th March.
Item 12.
Please, your lordship. Office note dated 26/2/24 lordship. Appears that we have not taken steps in the second mood lordship, but we have taken steps lordship. So what the first part is the average service report. Yes, lordship.
Raji, acknowledgement.
Five two. We have taken 5/2.
Lordship, may submit, perhaps we have sent our intimation to concerned OC, Lordship. Perhaps we.
There's something wrong going on. Because as per the office note, he has not taken steps. Now he's showing that he has taken steps. And if these steps has gone to you, it must be reflected here because these cases are otherwise liberty of people are concerned. So we'll have to rectify if there is any defect because these things must go and within time it should reach you and then it has to be served through the police station.
Perhaps we have sent our intimation.
No, we don't know because it's not here, but let me call the criminal staff. No, we'll have to call the criminal staff of the criminal section because this has to be rectified. If you are making a mistake in handling of steps, it is not good for the system. Correct. You may have sent it, we are not doubting you. The question is that it should reflect in the orders or note sheet also. Note sheet says steps not taken. He is showing us steps taken. Just wait for some time. We are giving the acknowledgement with us for time being.
Item 13.
Take a look, this case. And as per the report, 26/2/2023, this was that. This is appeal against Secretary of Municipal Instrument Act case.
Supplementary file.
Report dated 26/2/2020. Issued on 29/1/2024. With a delay of 35 days.
Uh, Mr. Sharma, we have partly gone through this record. The court has disbelieved that you gave a loan. And this is supported by the cross-examination of the PW1 and PW2, who say that you paid some amount of money in smaller denomination of 500 rupees, 1000 rupees, 2000 rupees, and accumulated to 3,50,000. Now you are running a beauty parlor. So if you have, and you took a plea that the money was your mother. She took a plea that your the daughter, that is the appellant, went to the bank, withdrew money, and then gave it. But that there's no evidence at all. You have not produced a statement of account to show that the amount was given. The true and faithful accounts has not been maintained. There's no document to show that accounts has been maintained. And therefore, the primary evidence of giving a loan of 3,50,000 is not there. Number two, once you say that you are given loan at the denomination of 500, 1,000 and 2,000, that means let us assume it is 2,000 rupees per installment is 2,000. 3,50,000 rupees would be 175 transactions. Correct. I'm wrong in multiplication and division, but 175 transactions. Now, 175 transactions, you become a money lender within the meaning of Money Lenders Act 1934, for which you have no license.
So see, in the first, my submission this part, because as the appeal has not been numbered because of delay of 35 days, see. So.
No, 35 days is okay, but
And then, Lordship, I will come to, if that is, I will come.
no,
to
no,
that
no,
part
no.
because-
Because we'll allow your continuation application and dismiss the criminal petition.
No,
And then we'll direct the criminal petition to be listed, to be registered.
Then in coming the appeal, I have a merit in the case, I will come to that part.
Yes.
And because I thought that it will, probably I'm not going through regarding just on the limitation, holding that, the limitation. Now, Lordship, even though I read also, no, Lordship, only, that is my.
No, it's okay. We'll take it up on Friday or Friday.
Yeah, Lordship can say, because I, that only assume, because I can, because their 313 statement was only there.
No, you see,
So taking advantage of that part from the PW to PW3. Denying is not that, because burden is on that part, because they issued the check, everything was filled up by
no,
them.
you are arguing or you are taking an
No,
adjournment.
I will taking that time only.
Okay,
Not
okay.
any time, short day,
Okay.
anyone did.
Then
Because I thought that
Friday.
it will first be admitted, then.
No, 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 no. Nothing of that sort.
That's it. If,
Once I have read it.
the Lordship, yeah, if at two, in Lordship can take up.
No, not two, because then I'll be hearing a parted matter. Friday then. Okay.
Stop mark. Friday. Yes, I'm ready.
Okay. List on
Yes, obliged.
3/20/24 as paid for by Mr. B. Sharma, counsel for the applicant. Ms. N. Dasland, APP is present.
13. Item 12,
In this case, you have taken steps, let them examine it. Within 1 or 2 days, they will just check it out. Uh, but Mr. Ardev, counsel for the appellant, and Ms. N. Das, APP for the state. Next paragraph, contrary to the office note dated 26/2/2024, the learned counsel for the appellant has submitted that he has taken steps for service of notice on the respondent number 2 through the jurisdictional police station wide. Acknowledgement. Bearing document number 1/2024 dated 5/2/2024. First of the AOJ criminal appeal section shall verify the same and process the notice. And do the needful in terms of order dated 19/1/2024. Notice is made returnable on 27/3/2024 through the jurisdictional, which police station? Nazira Police Station, officer in charge of Nazira Police Station. The Office of the Public Prosecutor, Assam at Guwahati High Court. Next, the officer in charge of Nazira Police Station shall ensure that the service report is returned prior to the next date of listing. List of 27/3/2024. Yes, in your
Time
case also.
being item 6.
The registry will do the needful. Mr. A.K. Das, Senior Counsel, assisted by Ms. S. Newar, Counsel for the appellant, and Mr. K.K. Das and APP for the state. Next, the registry shall hand over the process to the Office of the Public Prosecutor, Assam and Guwahati High Court for onward service on respondent 2 through the jurisdictional, to the officer in charge of jurisdictional, which police station? Bangaigaon Police Station. Most of the notice is made returnable on 27/3/2024. Most of the officer in charge of same order, officer in charge of so and so shall ensure that the service report is returned. List on so and so. I will be taken up on service of notice on respondent 2.
Supplementary item 17.
As respondent number 2, madam. But my lord, neither my name has been reflected, neither the brother colleague has sent me the copy of the memo and the IE.
You want a copy of memo appeal?
But as per the order dated 16/2, my lord, it was directed that the council will furnish me the copy of the appeal memo and the IA. He informed me about the matter, my lord, but he did not serve me the copies, madam.
I think you'll take about 4 weeks time to compile it and give it to him, or 6 weeks, 8 weeks, 10 weeks.
Now, Lordship, Prasad is ready.
But you see, when somebody asks you for a copy, you should give it. Today you'll give it. Okay. the Mr. L.R. Mazumdar, counsel for the applicant, undertakes to provide copy of memo appeal to Mr. uh, A. A. Tiwari, learned legal aid counsel. And amicus curiae for the respondent, number 2, Mr. Miss, huh? We will give you this. As well as to Ms. Andas and APP for the state. Next paragraph. It is noted that the paper book is ready. The registry shall provide a copy of the paper book to the learned APP as well as the learned counsel for respondent number 2. You have got it? Respondent number 2. Within a week. Oh no, paper book to you is given. Accepted by Asaduz Zaman Ahmed.
It is for the appellant. Because this is for the.
Oh, it is for the appellant. Acha, public prosecutor A. Decca has signed it. Yes, just check it up. You note it so that. Paperwork is served on the appellant and the learned APP. However, a copy thereof be provided to Mr. A. Tiwari, amicus curiae for respondent number 2. Just check it out. Okay, the registry shall reflect the name of Mr. A. Tiwari as amicus curiae for respondent number 2 while listing the matter next. You filed your objection in this IA? You have to file. Already filed.
It's filed on lordship 8/9/2023.
No, it's okay because this is, I did not check it. That's why I'm asking. Yeah, fine. Okay. Tiwari, Mr. Tiwari, you filing objection?
Well, I will see the records and thereafter.
Oh, okay. Objection, if any, within 2 weeks. List the matter after 3 weeks. Okay.
Like.
This 3 weeks will be IA. And this, what do you call this? Appeal, it will be real course.
Supplementary item 18 to 30. বুজিছে নে? এতিয়া উঠি আহিব নালাগে হা তেওঁৰ লগত মিলি এইটো গোটেইকেইটাতে 6 আছে কপি না When?
Yes, yeah. Just a few gaps. Yesterday, on 26th, you are referring to case of Sinam Gune Singh. In that case, you were referring to exhibit 18/2, which is a uh, which is a revenue collection sheet for the year 2007. Now, who is this PW? The PW name I did not record. PW number is 18/2. Missing. Missing the bottom to a Exhibit 18. 18/2, you said that it is an attachment containing revenue collection sheet for the year 2007 by UNLF. Right. ₹44 crore said was the collection. Perhaps not. 18/2. No, you could have made a mistake because that's why there's a gap here. You see, in this Sinam Gune Singh, you first said that they were providing maintenance to the families of A8, A9, A10. Exhibit 115/714. Yes, I remember. Now, who is that witness? PW5, 115 of 714. N Bhaskar. M Bhaskar. PW5. Okay. And this 18/2, exhibit 18/2. That family. That was no revenue collection. There's a document there of revenue collection. You said that in year 2007, they collected 44 crore rupees that year. Oh, yes. In 2007. Give me some time. No, it's okay. We're just telling you. Once Mr. Das starts, I will. No, it's okay. No. What we are saying is that there are certain gaps. Yes. So we want to fill it up. Yes. Then there is a photograph, page 113, part 2, volume 1. 812. Photograph of 812. Page 113, part 2, volume 1. 113, part 2, volume 1. Who is the witness who proved that? Serial number 127.
Yes.
Who is the witness who has proved this?
This, this happens to be a part of the,
No, either 62 or someone
No,
he sent, but
yes.
who is that? I forgot.
right, I think I'll make it.
PW5, no. This is that A12. Photograph A12, page 113.
Yes, this is exhibit 18.
This is exhibit 18.
Yes.
Okay.
Exhibited by PW5. They were the senior scientific officer,
PW5. Okay.
Exhibit 18.
Then then you said that his photographs were compared by someone.
Yes.
Two photographs were compared. Who did that comparison?
Gangwar is.
Gangwar is 44.
He compared all the.
Now, there was this monitoring of the arrest of cadres at Guwahati.
Yes.
This you were saying in respect of A12.
Yes.
You had referred to page 150. Which part of which volume I forgot to record.
Mail. Yes, Lordship.
One you showed is
That was
449. That is part 2, volume 2. Then you referred to page 150. I forgot to note this 150 of
115, 115.
115 by 176. That is
That is 115 by 1 is regarding arrest that I showed your Lordship.
115 by 1 is that
Email regarding.
email of arrest.
Yes, Lordship. And with regard to three.
Which page is that?
I'll just.
One is 449.
I'm just. Yes, that is regarding arrest monitoring which Lordship.
Yes, and
that
then
is
you also
422.
refer to page 150.
422. This arrest is 422 regarding arrest of 11 cadres which I said they were monitoring.
422,
422 in part 2, volume 2.
part 2, volume 2.
Part 2. And the treatment which I was saying, which refers to Telemba. Telemba is one of the accused. That Lordship will find at 441 of the same volume.
441.
4. That is exhibit 115 by 73.
115 by 73. This is 441.
Yes, page number is 4. Same volume, Lordship, part 2.
Okay.
Volume.
Then 150 is a mistake or
What?
page 150?
Lordship is 150 has been indicated against Lordship.
For that arrest only.
150 Lordship, I did not refer Lordship.
Is it 450 then? In connection with the arrest, I have recorded one page is 449 part 2 and one page I have recorded is 150.
I'll just check. There I go volume to what?
150 if it is there, it's only part 2 or part 1. Either of.
Perhaps why we say
Perhaps it's an error.
150, even in my book, I do not find.
No, it's okay because there's some gap this way. Having interest in medical, I think my handwriting is also converting to.
Yeah, if you remember, like, I what, because in the Chief Justice's court in the old building, around 20 years back, somebody had produced a prescription of a doctor, and nobody was able to make the head painting out of it. And the then Chief Justice called the doctor to the court, and like he was given a good dressing. Nobody can read your handwriting. How can you read your handwriting? And he was asked to go to school again to do his handwriting. Because, normally what happens in this, missionary schools, we have that
Cursive.
cursive writing. And I always face difficulty, and
In my court proceedings, a document was produced and I had doubt about the handwriting. And I posed a question and to the lawyers present that which is the school which which inculcates habit of similar handwriting in all the students. Because the question was that the handwriting is same and therefore this is copied by this is not the original handwriting. Somebody it's a what do you call, one person is writing both.
in fact, this
So then I told in Guwahati there is one school, and it's a girls' school, where all girls have same handwriting. So only one out of all the lawyers present, only one could answer.
Lordship, the same query was made, if your Lordship will remember, there was this police selection case for the former CJI in the whole building. Trunkloads of papers were brought, and all handwriting was the same. So therefore, a doubt had arisen. How could it be of one handwriting? And the explanation given by the police officer present in court was that they teach those who write in the same manner. Trunkloads in the same handwriting.
It's possible.
No, that's not possible.
Because if you have an inculcating habit of cursive writing, then handwritings will be better.
I never could do it, but you also asked me the impresses, right? And I changed my handwriting.
No, you see, you try writing with a ball pen, you try writing with a ink pen, you'll find the difference.
Yes.
Ink pen is always better. Okay, so now there's one more, two more gaps. One is the sample photographs as page 205. You had shown us page 119 to 1123,
Yes.
part 2, volume 2, and then you refer to exhibit 115, which is referred at page 423, part 2, volume 2. Now, what is that exhibit number 115 by 423, part 2, volume 2?
Just now I saw it. Take a take a good look. Part 2 volume volume one. Volume one.
I have noted part two, volume two, page 423. Exhibit number, I left blank, 115 by,
Lordship has recorded is wrong. Part two, volume two.
I might have made a mistake, that's why there's a gap.
423 is a mail,
Huh?
is a email, not photo.
No, you were referring to that photograph and then referring to this email. 423 and exhibit 115 by 73, which is at 441. These are two documents you referred. In this, that's Telemba. This is about Telemba. 115, page 423. I might have made a mistake in noting.
Telemba photo appears
441, that is 115 by 73. But then this 423, part 2, volume 2, I have recorded.
441 I referred for the purpose of medical treatment.
Huh,
It's not for the photograph.
okay. But what is this 423 then?
Twenty.
423, part 2, volume 2.
I did not refer, 422 I referred,
422,
yes,
okay.
422 I referred.
Okay, that is
That is the rest of the 11 patents.
442. This is 115 by 1,
115 by 1, yes, 422,
422.
yes.
And then you refer to 313 statement of A17
Yes.
at page 855, 858. Question number 13 and 29. This is at
Yes.
part, which volume?
Part 1, volume 4.
Question number 13 and 29 you read.
Yes,
Okay, that's all.
13 and 20.
Only one thing remains, that is 18 by 2.
That I will. Lordship, I wanted to address your Lordship on the aspect of section 20 of the UAP Act and section 65B. Other evidences are over, Lordship, subject to what my senior will also make some submissions. But a few things have come to my mind, which I would like to place before your Lordship. Lordship, an argument was advanced by the appellant with regard to section 20. And an analogy was drawn from the case of Kalpanath Rai, which is reported in 1997 8 SCC 732, that And that particular case relates to Lordship Tada. And the Honorable Supreme Court at page 35 of the paragraph 35 of that judgment, Your Lordship has that 1997,
1990,
1997, 8 SCC 732,
8 SCC
732.
732.
Mishra sir have taken your Lordship. And referred it to one point of time. A submission was made, which is based on this particular judgment. I'll just read out paragraph 35 for a moment.
Suggestion is at page 75 of compilation.
Please read.
Page 75 of compilation 2.
Paragraph 35.
Paragraph 35 is at page 90.
Para 35.
Para 35 of the judgment. Now, his reliance was primarily on paragraph 35. It states, there are two postulates in subsection 5. First, that the accused should have been a member of a terrorist gang or terrorist organization after 23/5/93. Second is that the said gang or organization should have involved in terrorist acts subsequent to 23/5/1993. Unless both postulates exist together, section 3(5) cannot be used against any person. An argument was made that he might be a person from the UNLF, or he might be a sympathizer of the UNLF, but that has to be coupled with the fact that the UNLF has to be involved in terrorist act, if I have understood. That's your permission. And in this case, there nothing has been shown. Case at hand, nothing has been shown that the UNLF had committed any terrorist act as mentioned in section 15 of the act. Section 15 and is parametered to some extent the provisions of the Data Act. Now, to understand the UAP, I may take your lordship to Article 19 of the Constitution. That is protection of certain rights regarding freedom of speech, etc. All citizens shall have the right to freedom of speech and expression to assemble peacefully and without arms, to form associations, unions, or cooperative societies, Lordship will mark C, to move freely throughout the territory of India, to reside and settle in any part of the territory of India, to practice any profession. Now let's come to it, 19.2. Nothing in subclause A or clause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interest of the Lordship will mark sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency, or morality, or in relation to contempt of court, defamation, or incitement to an offense. This right is not absolute. It is reasonable restrictions may be there when the question of sovereignty and integrity of the country may arise. Now, Lordship will come to 19.4. Nothing in subclause C of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interest of the sovereignty and integrity of India or public order or morality reasonable restrictions on the exercise of the right conferred by the said subclause. Now, if we look at the UAP Act, Lordship will just bear in mind, constitutional amendment was brought in 1963. Sovereignty, integrity were inserted in clause article 19.2. And if I may take your Lordship to the introduction and the statement of the UAP Act. The National Integration Council appointed a committee on national integration and regionalization to look into inter alia the aspect of putting reasonable restrictions in the interest of the sovereignty and integrity of India. Pursuant to the acceptance of the recommendations of the committee, the Constitution 16th Amendment Act 1963 was enacted to impose by law reasonable restrictions in the interest of the sovereignty and integrity of India. In order to implement the provisions of 1963 Act, the Unlawful Activities Prevention Bill was introduced in the Parliament. Then a statement of objects and reason. Pursuant to the acceptance by government of a unanimous recommendation of the Committee on National Integration and Regionalism, appointed by the National Integration Council, the Constitution 16th Amendment Act 1963 was enacted, empowering the Parliament to impose by law reasonable restrictions in the interest of the sovereignty and integrity of India on the freedom of speech and expression, right to assemble peacefully and without arms, and the right to form associations or unions. The object of this bill is to make powers available for dealing with activities directed against the integrity and sovereignty of India. Now, having understood this, if we see the schedule to this act, schedule 1 of the UAP. In my book, Lordship, UNLF is at serial 14 in the first schedule of terrorist organization. Yes, there. UNLF was an organization, Lordship, which was born somewhere in the 60s. And thereafter, this organization has been put in the first schedule. Now, how, before putting any organization in the schedule, there is a process to go about. How? If I may take your Lordship to section 3 of the UAP Act. Section 3, declaration of an association as unlawful. If the central government is of the opinion that any association is or has become unlawful association, it may by notification in the Gazette, official Gazette, declare such association to be unlawful. Every such notification shall specify the grounds on which it is issued and other particulars as the central government may consider necessary. Provided that nothing in this subsection shall require the central government to disclose any fact which it considers to be against the public interest to disclose. No such notification shall have effect until the tribunal has by an order made under section 4 confirmed the declaration made therein and the order is published in the official Gazette. Now, Lordship, I have यार ऊपर तो कुछ बोल ऊपर कागज का क्या लगा Lordship, if I may. Draft copy আছে না? Lordship, if I may pass on notification. Sorry, Lordship, in one said, Lordship, the notification has not been attached. So
Yeah.
this is this is also related to an organization of Manipur. That is a PLA. This is one of a kind of a notification which would have been issued in the case of the present organization also. And thereafter, what happens is, this is, first is the notification, then it goes to the tribunal under section 4. Yes, yes. Lordship. In the meantime, I'll make a photocopy of. Having that, Lordship. Where an unlock under subsection government have within application. But the notification tribunal for the purpose of adjudication or not, there is sufficient cause for declaration unlawful. On receipt of a reference, one, tribunal shall call upon the affected by notice, writing 30 days of the same by the unlawful. After considering cause, or member tribunal shall hold inquiry undertaken. And after calling for further information as may be, as it may, or shall decide whether or not lawful and make such order as it may. Either coming the or cancel the same. Order on the subject. Now, organization made unlawful only after going through the years of not that the government has the declaration, they are unlawful. But organization had an opportunity opposite party, that is so-called unlawful organization. Declaration is
There will always be something up the sleeve. You've seen that. Now you see association or meeting of people. Will that itself be unlawful? Then your home minister goes. Correct. So merely meeting people would not constitute an offense. This is an example. You show to Mr. Das also, he will also like to smile.
from this particular news item, I have come to learn that it was found sometime in the 60s.
November 23. No, you see the argument which is being advanced by both of you is that once these people are in association with the higher ups and they are somebody meeting an UNLF chairman, itself is sufficient proof of being involved in a terrorist activity. That is the argument. Now we have on record one of the power centers in the country meeting UNLF and having an agreement signed. Now it must, you see, number one, it is an unlawful organization. So meeting people who are unlawful, that is one part. Second part is having an agreement with that is another. But for both those things, there must be meeting of people with the leadership. And therefore, what we are asking is that every meeting with the chairman would not ipso facto make a person
Correct in that a one-off meeting will not constitute. The regular meeting.
no, this you see, this you can't say that a peace pact of this sort had taken place only in one meeting.
The objective of the meeting is different. The objective of the meeting is different. So Moshik has seen the objective of the act. That's not condition. We don't know Moshik, if prior to winding up of this case.
No, you can avoid this by saying it's a political question and we won't reply. For that, there is nothing, no evidence to that effect that the tribunal passed an order. You see, something is added in the schedule that is automatic. Yes. It's only a declaration thereafter, which no, the entry you see, this provisions you have said 3.3 and 3 and section 4. It does not say that the entry in the schedule, first schedule, shall only be after the order of the tribunal. That's not there. So therefore, number one, that notification is issued, ipso facto allows an entry to be made in the first schedule, but it will not be implemented till it is there's an order by the tribunal. So therefore, entry may be there by an executive action, but subsequently it is the tribunal which also gives a declaration. So unless the declaration is shown, we don't know that whether the entry made in this first schedule is backed by an order of the tribunal. That's the query. No, we don't know. We don't know because you see this. There's also there's also something more. Section 6. No, you see, the section 6 is very clear. It shall only be 5 years. Therefore, even if you accept your statement that in 60s it was declared as a unlawful assembly, so it is 5 years. So there should be an extension from time to time, which is current. It will the currency of that period. Yes.
Had an organization in the first schedule, name of an individual in the fourth schedule. Also had an organization in the first schedule, which is identified as this organization. These are resolutions adopted by the State Council in the State Habits of the Council of the United Nations of the name of an individual in the fourth schedule to conduct international diplomacy. Remove an organization from the first schedule for the name of an individual from the fourth schedule. And then first schedule or the first schedule is from other Central government shall exercise clause A of subsection 1 in respect of an organization or individual only if it believes that such an organization or individual is something for the purpose of section 2, an organization shall be deemed to be involving in such organization or individual groups so participates in acts of terrorism of the state or terrorism.
So you see, just interrupting you for a moment, that is why Mr. Mishra's argument was twofold. Number one, if the tribunal to be declared was declared unlawful under section by operation of 3(2), 3 and 4, then the entry in the first schedule is not otherwise required. Because it's a declaration which is backed by an order of a tribunal, and therefore 3 and 4 takes it starts operation. Now, if it's a declaration made under 35, then it does not require a concurrence by a tribunal. That means this is being done on the basis of an executive action of the state. This is what his argument was. Initial argument that he started with that. Therefore, he made a distinction between two parts. First is a declaration under 3, and then subsequent order by tribunal under section 4, the effect under section 5, and then 35. 35 is totally, as per, if you have understood him correctly, he gives, his argument is that it is a separate executive action altogether. Because that's why when this question was not put to him on the tribunal, because he did not argue on this section 3, 4. He merely made a reference. But when you are arguing on 3 and 4, that's why we pointed out 6. So because if it is 3, 4, then 6 is the last consequence. And if that evidence is not there, we will have to take it that this entry in the schedule, because 3 and 4 does not say, once an order is passed by a tribunal, it amounts to an amendment of the schedule, first schedule. So therefore, order of the tribunal doesn't amend first schedule.
In respect of an unlawful association.
Unlawful association, that's okay, we'll take it for the time being. Let us, we accept it that both are same for the time being, for the sake of this provision. Just a moment, because section 35, before you make your submission, section 35 is amendment of the schedule. So amendment of the schedule is ipso facto, it's a what you call executive action. Doesn't require the tribunal. And he's also right when he's explaining it, association, this is organization. Yes, we have seen that, anti 4, 5, that's. Huh. Yes.
Now, if your lordship can see the next page, this page before the tribunal. Here, only after the tribunal confirms.
We will not be able to accept it, because you see, tribunal is something which I have dealt with. I've been a presiding officer of the tribunal for NSC and K. Now, therefore, some idea of this. This notification will start from section 3. You see this notification, come to this notification. Second last paragraph. Now, therefore, it exercises the power conferred on one of the 3. Or so and so declares anti-extremist organizations, namely so and so. and so with all their fraction means an unlawful association. So you see, they are, although it's an organization, they're declaring it to be unlawful as an association. Last line would be, last word of that notification is an association. This second last paragraph. Last word is association. So therefore, notwithstanding that it's an organization, it starts with an organization, ends with association. Therefore, intention is specific to section 3 and 4. So nowhere in this order, you will find a reference to section 35, 36 or 38. So it is not for that purpose. Subject to your instructions, because I am, we only go by the text of the order of the section. We don't have the instructions. We go by the text of the provision. Just a moment, let's just interact with my brother. Just while we are at it, can you see, can you come to section 2L and 2M? 2L is terrorist gang, means any association other than terrorist organization. So this is excluded. Now M is terrorist organization. It says terrorist organization listed in the first schedule. Therefore, it's a clear-cut distinction by the statute. So therefore, you see, there is another connotation of your argument, which is for the purpose of sections 20, if there is an offense. And if there is an offense within the meaning of section 38, it will have two connotations. So once you formulate your argument, because it will have an ripple effect with regard to the offenses under section 20 and section 38. So please think over. It has a ripple effect. Without your noticing, it has a ripple effect. So no, I mean, you see, we are just, you see, it's a question of assistance to the court. We are not on the, what you call, not on the submission itself. What we are trying to caution you is that your argument may have a ripple effect. Because this will not have it. Yes, yes. No, it is no point reading it, because you see the essence of this the last paragraph, two paragraphs are, you see, we have shown you section 6. Now the effect of this is for 5 years. Correct. So it is in consonance with section 6. And therefore 30, this, what you call, declaration of 35 is not envisaged. We are not stopping you from arguing, but because you see this 35, when it comes, then there are review committees. And then this amendment to this schedule is laid before the parliament under 35(5). So it's a clear-cut distinction. Order of the tribunal doesn't go to the parliament for ratification. Parliament acts independently. It is only in this aspect we are just cautioning you. You reformulate it. No, you can reformulate it in second half and then address us again. You can sit down, take a discussion.
And shall also be liable to fine. Now, let us see section. Schedule is under 13. Schedule is under 13.
Which provision you read just now?
20 section.
20, okay, okay, yes.
Central government may have notification of official guidance, then I will have of the meaning of promotes or entry. The central government or remove.
Compare it with section 6. There's a proviso. You see that, you will understand. Nothing to do with your submission. It's only academic purpose. We are just trying to show the distinction. No, no, not that. You see, it's only a question of interpretation of law. So unless you assistants will not be able to do anything. So it's just an what do you call? It's a open thought process. No, we are not saying anything which is right or wrong. It's only we are invoking a thought process so that. No. You see, no. We are not. We are telling you, when we are discussing law, it's not a question of right or wrong. We just need a correct interpretation. So it's not that I am wrong or you are wrong or Mr. Prasad or Mr. Singh is wrong. It's not that. We're trying to interpret so that as an officer of the court, you give the correct interpretation, only that much.
Have been put satisfied. Four parameters. You that has not been. Now, once positive is found, unless provision of
That also under section 36, the government itself can't do it. There's a review committee. Review committee, if it accepts, then the recommendation will be taken up by the government, placed before the parliament, and then
this process.
Hmm.
That is not. Therefore, once has to be that the parameters under 35(3) have been met. Caution. If the appellant is punishment. The member of or a terrorist or a terror. Now, counting those. After we have. Therefore,
That was the submission.
you remember yesterday when we started the proceedings, I accused Mr. Mishra of threatening the court by bringing a lot of bundle.
yes,
So we had reasons to believe that by bringing, when Mr. Prasad was checking in luggage into this building, we had reasons to believe that he is threatening us with volume. Correct? So we had reasons to believe. But he ended up in asked time. Correct? So that reasons to believe. No, that's okay. No, that's okay. But you see, these reasons to believe was proved to be erroneous. Now, section 35 requires reasons to believe. If the central government has reasons to believe, it enlists a organization as a terrorist organization under first schedule. But section 20 says, you read the text of 20, it says terrorist organization involved in terrorist activity. So you see, in a criminal jurisprudence, with reasons to believe we can't convict. there must be something more than reasons to believe in section 20. Because you see 35, we once again I will reiterate, 35(2) says the central government shall exercise power under clause A of subsection 1 in respect of an organization or an individual only if it believes. Correct. So it ends here. Now 20. Any person who is a member of a terrorist gang or a terrorist organization which is involved in a terrorist act. So some terrorist act has to be attributed for the purpose of punishment. You see, reasons to believe, we are once again explaining our question. Reasons to believe may or may not be linked to a criminal act. Today, 10 people are assembling at a particular place, and the government has reasons to believe that they will commit a terrorist act. You see, terrorist act is also stopping of the food grain, what you call coming in the national highway. 15 covers that. So if it affects the life of an ordinary man, so therefore you come to know that X is a group which is being formed, and they will now go to the national highway and they will stop the what you call this from plying, and therefore you exercise jurisdiction under 35, saying that it's an unlawful assembly, organization or something, whatever that is, you think like. But it may or may not have committed an act of crime. Because this does not presuppose that there must be, number one, for exercising power under 35, it must be preceded by a terrorist act. Doesn't say so. Therefore, if you have reasons to believe, you declare it to be an unlawful organization. Now for 20, either you'll have to make an argument that yes, presumptive punishment can be given by presuming once it is there in the first schedule, then it is presumed that they had committed a terrorist act, and therefore we punish you under section 20. This is how we are trying to explain it, our query. I'll disrupt you for a moment again. You see, read that 20 conjointly with section 38. 38 is that if it is declared to be unlawful and you still continue to be a member, then you suffer a punishment of 10 years. So therefore, for the purpose of 38, who associates, and then there is to further its activities, commits an offense relating to membership. So therefore, you see here, terrorist act is not required. It is merely a presumption that you are collecting funds, you are doing this, you are trying to regroup and to strike terror in the within the meaning of section 15. and therefore you are committing an offense relating to membership, and therefore you are convicted and given a fine of imprisonment of 10 years. There it can be life. Huh.
Yeah, the support from staying at home. We are trying to connect them with some activity.
But they are punished under section 20, given imprisonment for 8 years and 7 years respectively, 18 and 20.
That's within Guwahati.
No, you're directly involved within the meaning of section 38. Because
Associates.
you see, we have two set of argument now. One, you are trying to develop vis-a-vis section 20. And one argument already made by Mr. Das yesterday was, not yesterday, before that was, that this the people at Guwahati, they were just like sleeper cells, and they were activated whenever required. So therefore, this is one set of argument which is advanced, where we are to construe this act of them at Guwahati doing some transactions as and when required by the higher ups of the UNLF. That is what was projected. So please bear that in mind also. We'll continue at 2. We'll continue at 2. We'll be maybe 5 minutes late. I'm coming back. Pardon me? No, it's okay. We are open. We are not. We are trying to understand. Section 20, 38.
Correct decision. Yes, by whatever.
No, see, decision we are ready to make, but if it is correct, then we have to think.
Fine. I'm saying. Judges end up in the some murmurs. Worship has given. They are very
My difficulty at times, I am hard of hearing. Many things I can't hear. N stands for what in your name? Moirangam, okay.
Lordship, we are on section 20. Lordship. The Lordship will take the act. We'll read very slowly. Lordship. Why? Why no act of terrorism is required to be attributed to the accused? That Lordship, if your Lordship will read the section, it is clear from there itself. Any person who is a member of a terrorist gang or a terrorist organization, thereafter there is a comma. Thereafter there is a comma, which is involved in terrorist act shall be punishable with imprisonment for a term which may extend to imprisonment for life and shall also be liable to fine. He by himself may not be. The organization, if it is involved, that is sufficient, and he would come within the definition of section 20. Here, for a moment, Lordship, I would just like to read out one paragraph from Waha Fasal. That case, Lordship has dealt with. Get a heavy to citation to 9. It is Waha Fasal to citation. I'll give the equivalent citation, Lordship. It is Manu SC 1000-2021.
This relevant paragraph is annexed to his compilation, Mr. Prasad's compilation. Compilation 3. No, brother. Compilation 3, page 87.
Just refer to paragraph 10. It's the offense
Page 90.
Yes, paragraph.
paragraph 10 in Manupatra. It starts with the offense punishable.
Yes.
The offense punishable under section 20 is attracted when the accused is a member of a terrorist gang or a terrorist organization which is involved in terrorist acts. Section 20 is not attracted unless the terrorist gang or terrorist organization of which the accused is a member is involved in terrorist act as defined by section 15. Now, he on his own personally will not be involved in any terrorist act. Once the organization is found to be involved in a terrorist act, that would be sufficient to cover it under section 20.
This is explained in paragraph 11.
Yes,
In paragraph 11, fourth line,
the
it
person,
is explained.
the person.
The person committing an offense under section 38 may be a member of a terrorist organization or he may not be a member. If the accused is a member of a terrorist organization which indulges in terrorist act covered by section 15, stringent offense. So here when the Supreme Court is interpreting it, this comma is omitted. But it makes no difference. This comma in section 20 is a bracketing comma. bracketing comma, you please come to section 20. This 20, I'll explain it to you.
Yes, Lordship.
Bracketing comma is a comma where you omit the words between a bracketing comma and continue thereafter will carry the same meaning. So now you see, any person who is a member of a terrorist gang or a terrorist organization. Now we omit which is terrorist act. Now it says member of a terrorist gang shall be punishable.
Yes.
So if you, this comma is basically a bracketing comma. In English grammar, this is explained as, like we use the word, he went there, comma, therefore, comma,
Yes.
he saw it.
Yes.
So therefore, this therefore is just unnecessary. It is a bracketing comma just for good writing it is used. Here, if you omit this bracketing comma, then also you get the same meaning.
If he is a member of that organization, that is also sufficient. If we remove that within the commas.
No, even if you remove it, you see the, again, same thing. 11 says, Supreme Court interprets, which indulges in terrorist act. So it can't be wished away.
If the person committing an offense under section 38 may be a member of a terrorist organization or he may not be a member. If an accused is a member of terrorist organization which indulges in terrorist act covered by section 15, stringent offense under section 20 may be attracted.
So you see, which means a non-living person, which means it's an organization. Or if accused was to be meant, then it would have used the word who.
Yes.
So who is not there? It is which means it's referred to an organization.
That is what if an accused is a member of a terrorist organization, it is a terrorist organization, he may not himself be. If the accused is a member of the terrorist organization which indulges in terrorist act covered by section 15, stringent.
So this terrorist act committed has to be proved.
Now, Lordship, by putting an organization in the schedule by virtue of section 35, there is a presumption which can be rebutted, by him, because we have put him on the basis of the parameters laid down in section 35. That he commits or participates in acts of terrorism, prepares for terrorism, promotes, encourages, or otherwise involved in terrorism. Now, if it is for him to show that he does not fall within those parameters, this rebuttive presumption is the onus would lie on him. We have done it. We have put him in the schedule based on the satisfaction under section 35 of section 3. So the onus will be on him to show that the organization, on him means it may be any other member of the organization, to show that they are not involved. Now, that also would, Lordship, if they are not involved, the logical action that would be coming forth from the organization would be something under section 36. When the Parliament has
It's a proposition difficult to digest. I'll tell you why. You see, we are keeping in mind the argument of Mr. Mishra, where he has distinguished the punishment, lesser punishment, and higher punishment. 20 is 10 years, 38 is 10 years, and 28 is life. Correct. So there must be, his argument is there must be some distinction. Correct. We are keeping that in mind for the time. We are not accepting it to be correct, but let us keep it in mind. Now come to section 36. 36(2) says the three category of persons who can apply. Number one, organization. Number two, any person affected by inclusion or organization. C is any person affected by inclusion of his name. Now let us say accused A. We are not giving numbers, we are just saying accused A. Now this accused A will not have a right to come there. If he does not want to espouse the cause of organization. You see, you are presuming X to be a member. Now X does not take a defense, he is just silent. And therefore, presumption is something which is not available in 35. Now, what we are trying to understand from you is that a person otherwise, let us say he is an accused, whether he has a right to come to court, come to the government to have the association, what you call it, to denotification of the organization, he doesn't have. Because he must satisfy two requirements. C is out. A and B, organization, he is out. So B remains. A person affected by inclusion of organization, he may not be affected. He may be a chairman, let us say, but he's not affected. It doesn't apply.
If he does not apply,
So the only presumption is that it is a terrorist organization, nothing more. It is indulging in terrorist activity. It's not a presumption provided under this act. Except for 43E. 43E is, you see, we're just what you call referring to the argument of Mr. Mishra, that he says that in this act, the only presumption available is under 43E. So we're just recollecting that. In a prosecution for offense under section 15. So 15 is out of question. So presumption to be drawn for the purpose of assuming somebody to be a member. That is a vehement argument made by Mr. Mishra.
unless lordship, if the organization is not affected from what your lordship has said, the name remains in the schedule. If the name remains in the schedule, the definition of section 20 is attracted. They have to rebut that. Until and unless rebutted, it stays. And there is no challenge to that. That would be my suggestion. So far as section 20 is concerned, lordship. I would, Lordship, limit my
Just, can I ask you to come to volume 1, part 1? (132). This person, N. Bhumi Singh, he is appellant in criminal appeal number 169 of 2018. Now, these are the charges against him. This is charged under 1, 2, 3, 4, 6 heads. Because so far as our limited experience goes, we say it limited because in this field,
We are
we,
also
we had a limited experience.
we are also
We're not denying the fact, but you see, what we understand is that when charges are framed against an accused, it is those charges that the prosecution must prove. Or if it is a presumption, then the accusation will have to say that it is presumed that you have done it. And if it is a presumption, then 106, you can very well argue that 106, the onus would shift. Or the burden of proof will shift under 106, not onus, but burden.
proof is always there, but
No, once there is a presumptive, once there is a presumption, then you just have to allege. It will be the burden of proof on him to show that he has not done it. 113A, for example.
here, then the organization has been placed in the schedule pursuant to the parameters in
No,
35.
you see, I think we are not able to express ourselves very correctly. You see, if you can just come to 113A, this is, I remember this, that's why I'm referring to it. 113A, Evidence Act.